Welcome back to the Armchair Attorney Podcast. I'm your host, Matthew Leffler, the Armchair Attorney, real-life lawyer, adjunct law professor at Michigan State University College of Law, an amateur moderator, maybe getting closer to professional. We'll see. Today, we have a great show for you. It's going to be hard-hitting legal mumbo-jumbo. So if you're not interested in hard-hitting legal mumbo-jumbo, might not be the best show for you. But let me tell you, we're going to break down two very important Supreme Court cases, one of which I will say is the most important law issue in this country right now. It is the most important case in my lifetime. I'm 40 years old. I suspect for many of you, it'll also be the most important case in your lifetime as well. And we'll talk about that. We don't have any guests today. It's just me screaming at you in the most professional and friendly way that I can. But of course, before we can do any of that, we have to do a little bit of housekeeping. So for the housekeeping, number one, pick up your trash. Doesn't need to be on the floor. And the clothes, they don't need to be on the floor of the bathroom either. Take those clothes and put them in the hamper. That's where they go. That's the housekeeping. Now, moving along, we have to say thank you to the sponsors, our advertising partners that help keep the thing going, the lights on, the camera rolling, and the microphone hopefully charged or it's plugged in. Get that going. First and foremost, our friends of the show, DAT, Dial a Truck. Since 1978, DAT has been helping people move freight and so much more. Over the last 10 months, DAT has transformed the business. No longer simply just a load board and matching platform. Oh my goodness. They have Outgo, freight factoring. You can get your money faster. Who doesn't love money faster? I don't know. I in fact love money to be as fast as practicable. And of course, Convoy platform. We remember Convoy. We learned about Convoy. Now it's owned by DAT. And of course, Trucker Tools, visibility for your supply chains. If you're new to DAT, and maybe you are, go to the links in the show notes. You'll find them on Apple and Spotify. You can download that little link, and then you get a chance to get 10% off for 12 months. That's a pretty good amount of savings. You deserve those savings. And of course, a big shout out to my friend Ken Adamo, Chief of Analytics from DAT. Just yesterday, Ken was with me in Chicago at the Chicago Traffic Club, and we had a debate of sorts. I was the moderator. Ken Adamo was one side, and Craig Fuller from FreightWaves and Sonar fame was on the other. There have been some great clips that have gone out there. You should probably see them right now. FreightWaves was kind enough to record this, stream it. You can find it on the X platform, LinkedIn, I imagine Facebook and Instagram. I don't know. They're at all these different places. Go find them, go watch, go listen, enjoy. It was a great time. It was a great time in Chicago. And most importantly, my oldest son and my middle son and my wife got to come and listen and see what the fuss was all about. So that was exciting. Now, our second sponsor, we have to give a great shout out to our friends at GenLogs. Lights, cameras, action. Freight intelligence is getting smarter every single day. And how do you do that? Well, how about a vast network of cameras across the ecosystem, monitoring trucks and trailers? Where is my freight? Chances are Ryan Joyce and team know. If you haven't heard of GenLogs, well, I can forgive you. But in the show notes, like I said for DAT, click the little link. It'll take you to their website. Check out a demo. This is incredible. This is a new standard of care when it comes to fighting freight fraud. And you know me, I don't like freight fraud, not one little bit. And the last piece, the thing I tell you to do is make sure your congressman and your folks at your local trucking associations or traffic clubs or TIA branches is pushing for CORCA. CORCA, yes, Combating Organized Retail Crime Act of 2025. This act would put resources underneath the Department of Homeland Security, help people coordinate better as they try to attack this big epidemic of cargo theft and fraud. You are talking about criminal cartels that are transnational. You can't do it alone. Congress needs to act, and I hope they act with CORCA soon. Okay, we've gotten that done. Let's talk about VOS selections. Now, it really isn't VOS selections anymore. Unfortunately, maybe fortunately, it is no longer VOS selections. The tariff case that has captured the American imagination. The case is now learning resources versus Trump. And I have been covering this issue, the reciprocal tariffs that were enacted under a federal statute called IEPA, the International Emergency Economic Powers Act of 1977. This is fundamental to your democracy. You must understand this. It's mandatory that you understand it. And as I got ready for today's show, knowing I didn't have any guests planned, I wanted to bring in a little clip. And I'm new, right? I'm an amateurish, semi-professional podcaster bringing in multimedia I'm not necessarily known for. Let's see if this clip works. Take it away.
What happens when the president simply vetoes legislation to try to take these powers back?
Well, he has the authority to veto legislation to terminate a national emergency, for example. I mean, he retains the powers in the background because IEPA is still on the books. But if he declares an emergency and Congress doesn't like it and passes a joint resolution, yes, he can absolutely veto that.
Yeah, Congress, as a practical matter, can't get this power back once it's handed it over to the president. It's a one-way ratchet toward the gradual but continual accretion of power in the executive branch and away from the people's elected representatives.
I disagree with that, and the recent historical counterexample of Congress's termination of the COVID emergency demonstrates that the political oversight
with the president's assent.
Meaningful.
With the president's assent, in fact,
once he lost it by a veto-proof majority in the Senate, I think the position moved. And I think he realized, and that's the political process working. There was a political
it takes a supermajority, a veto-proof majority to get it back. Yeah. Okay.
Did you hear that? Did you hear what was said in that exchange? Okay. I got to dial it back. I got to come at this impartially as best I can. That was Neil Gorsuch. He's a justice of the Supreme Court, grilling the Solicitor General about what the Trump administration's argument is for IEPA. Let's back up because I think we need some context, because we're going to play that clip again after I take a few minutes to explain to you why that clip should terrify you and why we all, Republican, Democrat, Independent, or otherwise, need to be deeply skeptical of the executive branch. This is fundamental table stakes of ordered liberty. Now, here's the deal. We all know that there are powers that a president has in an emergency. Those powers that are there in an emergency are not necessarily enumerated in the Constitution. Sometimes they're implied. We think that is the power. So if there's an earthquake, or there is an attack on your soil, or some, really scary thing that the caldera in Yellowstone explodes, you don't want the president to say, I can't do anything until Congress tells me I can. I have to get Congress to tell me first, and then I'll do something. So the emergency powers are important, and they serve a very particular purpose. But what is an emergency? That's the fundamental question we start seeing with IEPA. So back in April of 2025, President Trump invoked IEPA and said, we have an emergency. And the emergency at the time was, it's fentanyl, it's illegal immigration, it's trade deficits. But again, it's not really reviewable what an emergency is. The president simply declares an emergency, and these powers are then found. IEPA, like many statutes, has very specific language. And in that language, there is nothing. There's not a single word that has to do with tariffs, raising of revenue. If you go back in time to the Federalist Papers or the Anti-Federalist Papers, when they were debating about the new Constitution after the Articles of Confederation failed, the two powers that were sacrosanct, the most important powers for the congressional members, was the ability to declare war, the ability to raise revenue, the ability to taxing power. Now, what happens is when Trump declares the emergency and then puts these tariffs on foreign goods from all across the world, that is a revenue-raising piece. That is a tax-raising piece without any clear authorization in IEPA that he can even do that. It's just implied, perhaps, that he can do that. Well, it's challenged at the Court of International Trade, a lower federal court. And in May-ish, the lower federal court said, wait a second, you can't do that. You can't create a tax without Congress giving you that authority. It's just not possible. And so for one single day, all of the reciprocal tariffs were gone. They were gone. Now, what is interesting about the use of IEEPA when it comes to tariffs, if tariffs are even possible at all, is there's no threshold. There's no time duration. There's no maximum or minimum. It is unclear if it actually allows that at all. So it went to the federal appellate court, the court above the Court of International Trade. And at that appellate court, the next court up, they looked at this and they ruled en banc, which is to say a bunch of them all together looked at this litigation and they came to the same conclusion as the Court of International Trade. They said this statute does not authorize tariffs. The word tariff isn't here. And even if it did, we may not even think that Congress can give that power up. There's some powers you just can't give up. You just can't give them up. Well, then the Court of Appeals said we'll give until middle of October for the tariffs to remain, and then they're gone unless the Supreme Court of the United States of America weighs in. And they essentially dared SCOTUS to come in and review and give an answer. And so last week, just a very short time ago, this was in front of the Supreme Court of the United States of America. And going into this thing, I wasn't sure which way the court was going to rule. I actually thought maybe 5-4, maybe 6-3, that Trump's tariffs remained. But after reading the amicus brief from the U.S. Chamber of Commerce, an incredible brief that if you don't like to read pleadings, they can post about it and give you a summary. But in a nutshell, they said, look, we don't think this is appropriate. We don't want to live in a world where the next executive can declare an emergency and put tariffs on every single thing imaginable and have no way to stop it. We want to have accountability. We believe that if Congress intended to give up the power to tariff to the executive branch, they would have clearly said, we'll give up the power to tax to the executive branch. But they didn't say that. And so as I listened to 2.5 hours of oral arguments in this learning resources case, and you can listen to the entire transcript, the entire oral argument is on the podcast. You can just go to the last episode we did and you can just listen to the whole thing. And you ought to, if you really do care about ordered liberty and the three-legged stool that is our democracy. Well, here's what happens. It goes before the U.S. Supreme Court, and this exchange with the Solicitor General and Justice Gorsuch is exactly what this case is about, which is if the president, any president, can declare an emergency, the only way to undo that is by Congress. And Congress can basically pass a bill, and with essentially a majority from the House and the Senate, they can tell the president, hey, this isn't an emergency, get rid of it. But the president can veto that. The president can say, I still think it's an emergency. I don't care what you say. And so the only real way to stop the emergency is if you get 2/3, a super majority, a veto-proof majority in the House and the Senate to agree that there is no emergency. That is the only way you can stop this. Now, that is what is at heart with this exchange. We're going to play it again. And I want you to listen to Justice Gorsuch talk about the ratchet, talk about the accretion of power. And we'll be back to talk about that once more. So here we go. One more time. The exchange, Solicitor General and Neil
The
Gorsuch.
president simply vetoes legislation to try to take these powers back.
Well, he has the authority to veto legislation to terminate a national emergency, for example. I mean, he retains the powers in the background because IEEPA is still on the books. But if he declares an emergency and Congress doesn't like it and passes a joint resolution, yes, he can absolutely veto that.
Yeah, Congress, as a practical matter, can't get this power back once it's handed it over to the president. It's a one-way ratchet toward the gradual but continual accretion of power in the executive branch and away from the people's elected representatives.
I disagree with that, and the recent historical counterexample of Congress's termination of the COVID emergency demonstrates that the political oversight
with the president's
assent
assent.
Meaningful.
With the president's assent, in fact,
once he lost it by a veto-proof majority in the Senate, I think the position moved. And
right.
I think he realized, and that's the political process working. There was a political
it takes a supermajority, a veto-proof majority to get it back. Yeah. Okay.
Do you understand now? Do you understand the stakes? Here are the stakes. We live in a hyper politicized world. You, in America at least, you are party first, branch of government second. You are a Democrat in the House or a Republican in the Senate. You are not a senator first or a member of the House first. You are party first. And because of that, and that's a factor of a whole lot of reasons we won't get into today, but maybe in a future recording we might, it means that you need 2/3 to stop it. And that's practically impossible. That's practically the level you need almost to get a constitutional amendment on the books. You may like the outcome. You may say, I enjoy the fact that people have to pay tariffs when the things come into the country. I want this to happen. But do you like the means? The means is an emergency. The declaration itself, unreviewable by the courts or by Congress. No one can just say that's not an emergency. The only way to stop it practically is 2/3 majority of Congress. And that power doesn't go away. It accretes, which is to say it coalesces. It's like the formation of a planet or a star. There's a disk of accretion, an accretion disk all around the giant mass, and it pulls in more and more and more. I use this example to friends that I have that love this current setup. They think it's great. I say, imagine your worst political nightmare gets in place. Imagine your worst political nightmare says, I believe climate change is an emergency. And I believe, in fact, that it's internal combustion engines that are the problem. And in fact, I think any component that goes into an internal combustion engine should have a 5,000% tariff. How would you stop it? Could you stop it? This is the problem with the learning resources case, the thing that we all need to be aware of. When there's change, people say initially, that'll never happen. It's impossible. On the other end of it, they say, once it's already done and gone, it's always been this way. I'm not worried about this. This is what it's always been like. Why would you want to go back? What you have now is the period of normalization, the period where you're not quite sure this is what you want, not quite confident this is the outcome that we all want to see. I cannot tell you enough how important this case is, because it is the fundamental question of separation of powers and the checks and balances that our founding fathers and leaders anticipated and planned for. And they didn't necessarily plan for party allegiance. They did plan to an extent of state allegiance, like I'm an Illinoisan or I'm a Californian or I'm a Texan. Like they did think of that. And they built the Constitution with these three legs, the executive, the legislative, and the judicial, each one checking the others. But if you look at this case and take it at face value, you are facing government through emergencies. Why would you use any other tool if you're the chief executive than emergencies? And in fact, we live under many emergencies now. There are at least, over a dozen, maybe more, probably a lot more. And the average emergency declaration lasts for 10 years. This is the problem we see with Congress, which is to say the delegation of their power, their abdication of their responsibilities. And so if you're not following this case, you're not paying attention to this case, I can forgive you, obviously. It's a lot of stuff happening. a lot of stuff in the world. But this case should galvanize Americans at least a little bit to understand a bit more about this incredible machine that we built through the U.S. Constitution, this check and balance, the power to raise revenue, the power to levy war. This is what's up to the people, and the people's representatives are Congress. Now, I go back to the war power. They talk about that in the oral argument, the power to declare war. I could be mistaken. I've been mistaken before, but I think the last time the American Congress declared war was in World War II. And I think what happened was Japan attacked us. We declared war on Japan. And then Germany declared war on us. And we declared war on Germany. And that was the last time. After that, we've seen this police action, this, again, accretion of power in the executive branch. There are people, and I've met many of them, who do believe in a thing called the unitary executive theory. The unitary executive theory is, for lack of a better explanation, the executive branch is the most important and everything else falls behind it. Now, there were founding fathers, I guarantee you, I think Hamilton could be argued to think this way, that they wanted a king. They would love to see someone with crazy amounts of power, but that's not what we have. This is not what was ever intended. And so as you think about this case and we look ahead, I think probably end of spring, maybe early summer, the Supreme Court of the United States will make a ruling on the learning resources case. I'll cover it then. I'll cover it with my law school class here in the spring, and I'll continue to talk about it here. Because if you don't understand it, then I've failed you, because you can disagree. Please, please, please understand. I don't want you to agree with me. It doesn't help me if you just simply agree. You have to understand. You have to understand what the stakes are and what trade-offs you're willing to make. IEPA does not authorize the use of tariffs. If it did, they would have used the word tariff. They know how to do it. And even if they did use the word tariff, I am suspect that Congress could give up that power so easily to the folks in the executive branch. Now, I'm going to play this clip one more time before we move on to the next part of our conversation, which is broker liability and the C.H. Robinson case, the Montgomery case that's before the Supreme Court. But one more time, listen to this argument, which is Justice Gorsuch saying, okay, let's assume that this does authorize the tariffs. How do you stop it? Let's listen to it one last time.
What happens when the president simply vetoes legislation to try to take these powers back?
Well, he has the authority to veto legislation to terminate a national emergency, for example. I mean, he retains the powers in the background because IEPA is still on the books. But if he declares an emergency and Congress doesn't like it and passes a joint resolution, yes, he can absolutely veto that.
Yeah, Congress, as a practical matter, can't get this power back once it's handed it over to the president. It's a one-way ratchet toward the gradual but continual accretion of power in the executive branch and away from the people's elected representatives.
I disagree with that, and the recent historical counterexample of Congress's termination of the COVID emergency demonstrates that the political oversight
with the president's assent.
Meaningful.
With the president's assent, in fact,
once he lost it by a veto-proof majority in the Senate, I think the position moved. And I think he realized, and that's the political process working. There was a political
it takes a supermajority, a veto-proof majority to get it back. Yeah. Okay.
Veto-proof majority. Now, you remember this Solicitor General talked about the COVID emergency, and the point that he's trying to make was, but Justice Gorsuch, we had an emergency and we got rid of it. Congress said, get rid of it. And he said, that's because the president also agreed with it. The president agreed to get rid of the emergency. What happens when the president doesn't agree to get rid of the emergency? You have to noodle on that. You got to noodle on it. We'll talk more about that. But as the Solicitor General, interesting to listen to him speak, listen to what the arguments are. I believe, I've been practicing for 15 years. I do believe any American has the capacity and the aptitude to understand how this system works and how the different players impact things. I really want you to understand. And I hope that this was helpful. If it doesn't, we did the best we could. Pivoting. The next question before us is about broker liability. Let's talk about some quick facts, fast facts. If you look at the brokerage industry, that's the ones who are third-party logistics companies. They're over $100 billion of freight moves through them, far more than not even 150, maybe even close to 200 billion of freight goes through the broker's hands. In the United States, there are about 500,000, 550,000 motor carriers. These are trucking companies that move things. You have 25,000 freight brokers about. You have 4,000 interstate bus companies, and then you have millions of men and women that drive a truck every single day. And driving a truck is one of the most common jobs in over 30 states. For high school educated men, driving a truck is the most common job in every single state. But we have watched over the last 20 or so years, the percentage of freight moving between a shipper and a direct motor carrier change. 20 years ago, maybe 5% of all freight moved through the hands of a third-party logistics company, a C.H. Robinson, ITS Logistics, or whoever else you can think of. But as time has changed, it's different. Now, 20, maybe 25, maybe even 30% of all freight moves through the hands of a third-party logistics company. And there's a reason this has happened. To chase after ever cheaper, ever faster, ever increasing capacity, it required the innovation and the growth of new organizations. You go back 45 years, there weren't brokers, buddy. It was a regulated industry. Everything was done through essentially unionized motor carriers and contracts that were governed explicitly by the federal government. Those days are behind us. And we've seen happen is brokers have taken a far larger role in the transportation logistics space. Broker liability is about when can a broker be held responsible for the injuries caused by a negligent motor carrier. So the example I'm going to give is an actual real life case, not the Montgomery case. We're going to talk about that in a moment. We're going to talk about one you've all read about very, very recently. This is a case of a company called Hope Trans. Hope Trans is a motor carrier, I think about 100 trucks or something like that. And they were working with a brokerage. That brokerage was Covenant Logistics. So Covenant was the broker. Hope Trans was a motor carrier, and the customer, the one who was paying all these bills, was USPS, the Postal Service. So Postal Service goes to Covenant, says, Covenant, you get to move this freight. Covenant then finds Hope. Hope then moves the freight. Well, the driver for Hope falls asleep, is the understanding. And that driver then goes and has a catastrophic collision, and a few people end up losing their lives. And the question becomes, who is at fault? Who is responsible for this terrible, terrible event? Now, normally you'd say, well, the driver for the truck, that's the one who fell asleep. That's the one who crashed. And the answer is, yeah, the driver is responsible, but they are indemnified to an extent. The company that employs the driver, Hope Trans, they're the ones who's really at fault. That's their employee. That's their agent who went off and did something terrible. But here's the deal. Most of the time, these trucking companies simply don't have the cash or the insurance to absorb a case like this. And so what ends up happening is you look to the broker and you say, broker, you picked this driver. You picked this truck. You picked trucking company picked the driver, but you picked the trucking company. Your selection of this motor carrier was negligent. If you were being more attentive, you wouldn't have this driver, this truck number would never have been picked. Accident never would have happened. And if that was followed through, you would then take that verdict, or you'd sue both the driver, the trucking company, and you'd sue the broker and say, broker, this is really your fault. If you hadn't selected this motor carrier, that guy wouldn't have fallen asleep. This family would still be alive. And that argument has won in some places, not all, because behind the scenes of all of this is a thing called F4A. We won't get into what it's all about, but the pieces that matter for this conversation is that brokers are in charge of price, route, and service. That's what they do. They are not essentially guarantors of the performance of the motor carrier. They're they wouldn't exist as an intermediary if they were on the hook, generally speaking, for the actions of the motor carrier. That's why you have different corporations that are in these businesses and these deals, is limiting your liability every step of the way. So here's the issue. This set of facts: driver has an accident, the motor carrier, the driver is sued, and we look at the broker, you should be at fault. Our federal circuits have split. And this is something very important to understand. The Supreme Court of the United States does not have to take on certain cases. Their jurisdiction is something that they really do get to choose what cases they want to hear. Some cases they have to. If it's like two states that are fighting for something, they're going to have to hear that. But if it's an interpretation of federal law, they don't have to take your case. There's no reason unless they saw a circuit split. And that's what we saw happen with broker liability. In some places, this set of facts, accident with a broker involved, and people have big injuries, and they sue the broker. Some circuits, the Ninth has said that we do in fact believe that the motor carrier and the broker are both liable. The Sixth Circuit has also said we believe that the broker can be held liable. On the other hand, you have other circuits that have looked at the same set of facts and said, no, the broker is just in there as an intermediary. They're not promising that this motor carrier is going to do everything safely. I mean, that's what the federal government, the FMCSA, that's what they're supposed to do. And so the Seventh Circuit and the 11th Circuit have both said, we will not hold brokers liable for the negligence of a motor carrier. So now you have four circuits with two different answers looking at the same legal text. Now, this is why I'm so impressed with C.H. Robinson. And I'm going to be a little cagey here as to why exactly I love what they did. But here's what happened. Other brokers have been successful in making sure that they're not responsible for liability, but they choose not to or have fought going to the Supreme Court because they didn't want to jeopardize the win that they had at the lower court. Well, C.H. Robinson won at the Seventh Circuit. They won here in the Illinois region. They won that they were not liable for the injuries that were caused in this case called Montgomery. But they know that a circuit split is generally bad for their business as a whole and the industry more generally. And so they did, in fact, argue with the Supreme Court that their case should go up. It should go up. And broker liability for the 25,000 brokers that are in the United States right now, even if they don't understand it, it is the most important legal issue facing them today. Many brokers do not have any insurance that would cover a case like this. Some of them, the big ones, certainly do. But this is something that all of their industry is following. Whether you're the American Trucking Associations or the Transportation Intermediaries Association or anybody that has to do with intermediaries, this case matters. It matters a lot. And finally, just a few weeks ago, the Supreme Court of the United States of America said, we will take this case up and we will make clarity. So they will look at the language in this F4A. They're going to understand what level of liability a broker should or should not have. But what we will have, more than anything else, is uniformity. We need uniformity. The entire premise of transportation and logistics, especially on the regulatory side, is that we all play by the same rules. And if you're a broker, you have an accident that happens in California and an accident happens in Illinois, the liability is different. It's just different because those circuits view the same law differently. And so we will be watching to see what the Supreme Court does. I do have a habit of making predictions, and so I will make a prediction here. I think if we look at the current makeup of our Supreme Court, and I do think it's a fairly conservative court, my belief is the Seventh Circuit is probably going to be the one that has the winning argument. I think they're going to be found that brokers are not liable for the negligence of a motor carrier. And that would certainly be a win for the brokerage industry. But is it a win for the American motoring public? I don't know. I really don't know. I've been in these cases. I've been in cases where you have a driver who has a catastrophic injury, and the minute that accident happens, that driver is insolvent. They're bankrupt. They're done. They're toast. And that person who's been injured might have hundreds of thousands or millions of dollars of liability. What do you tell them? What do you do then? Does the system eat the cost? Probably. The system probably eats the cost. We live in a society, a transportation logistics industry that I believe is underinsured, poorly maintained, and not particularly regulated as well as it ought to be. I might be in the minority in that position, but I will maybe get to that here in a moment. But my belief is broker liability is finally going to the big house. We should all be excited and celebrate this. This is important for the industry. It will give consistency to both shippers and for brokers and for motor carriers, and it will give us a better understanding of who we can hold accountable when things go wrong. But as I said, there are other problems we'll have to wrestle with. One of the reasons why we look to brokers to be liable in these cases, because like I mentioned previously, the motor carrier doesn't have enough insurance. The minimum insurance to operate a commercial vehicle across state lines without hazardous freight being in the mix is $750,000. $750,000. That is a lot of money, but not as much as you might imagine when you're talking about really big medical claims. That number, the 750, was set in the 1980s, and it has never really been raised afterwards. It's not pegged to inflation. It's not tied to any type of increases at all. And so every time we've tried to raise that number, it has been shot down. Every interest group around says, we don't like that idea. And so you have motor carriers in many cases that do not have enough insurance. And so we look to the brokers almost as guarantors to tell us, hey, is this company okay? Now, here's the other problem. The FMCSA, that regulator I mentioned previously with the 550,000 motor carriers, the 25,000 brokers, and millions of truck drivers, they have 1,000 employees and a budget of $1 billion a year. They're not really in a great position to go out and inspect all of these vehicles. And they use the Department of Transportation for the states and the feds. But ultimately, the vast majority, 90 some odd percent, and Ken Adamo, if he's listening, I don't know if he is, would have the number. It's like 7% of all trucking companies have some sort of safety rating. The vast majority have none. So what do we do? What do you do if you're a broker and you have no data on the underlying motor carrier? Well, that's partially why we have the sponsors like Genlogs and DAT, because you can't just look to the feds to solve the problem. You have to do something else. You have to have some other vetting software, some other tie into the motor carrier. It's an interesting world that we see ourselves in. And I don't know if any of these changes make a big difference in the long run. But for now, the biggest issues in front of us as we step forward into 2026 is going to be what happens in the learning resources or VOS selections and what happens with broker liability. These two cases are incredibly, incredibly important. And I think it is something that we all need to wrestle with, because if you're a broker and you rely on the federal government and the federal government alone, you will go bankrupt. You will lose. You will not succeed. They are not doing enough. So you have to get all of these new tools. And if you're a broker, you might have Highway, you might have Genlogs, you might have Carrier 411, you might have any number of other technologies. And still, someone's going to come to you and say, you hired the wrong company. And because you hired the wrong company, you're at fault. And then you are faced with a verdict that will absolutely unequivocally bankrupt you. We've seen verdicts, these nuclear verdicts, over $10 million, thermonuclear verdicts over $100 million. There's only a handful of companies in the United States that can take that punch more than once. So as we gear up for 2026, the last piece we'll talk about, and if you have questions, throw them in the chat. I'll answer if I can, is the newest the new update on non-domiciled CDLs. So earlier this week, then there was an interim final rule the administration put out, the FMCSA, saying essentially we're going to get rid of the non-domiciled CDLs. About 200,000 or so people that don't live in the United States but have commercial driver's licenses. That interim final rule was challenged. It was put on an administrative stay. They said, pause, we're not going to do this. And then fast forward to just yesterday, the DC Circuit, the appellate court, came and said, nope, that rule is not enforceable. It is not going to be what you do, and we are knocking it out. So non-domiciled CDLs are going to continue to be something we see. I don't think the data necessarily supports that they're less safe. I think the FMCSA has some work to do as they put together their next little go around with the rules trying to remove these folks. But that is it. That is the two biggest cases that we had to cover today. We did it in 40 minutes. I feel pretty good about that. Again, this is your democracy. This is your supply chain. We get the supply chain, not that we want. You get the supply chain that we deserve. And you get it through the actions that you take, who you vote for, what positions you advocate for, what goals you have. And as we look forward into what I believe is the most important case in U.S. history, at least in the last couple of decades, this learning resources case, I am encouraged. I am very encouraged. I went in thinking the Trump administration would be successful in this fight, and I feel like that might not be the case. I think the change might be 5-4, maybe 6-3, that the Trump administration loses. Now, there's other vehicles they can go and use to put tariffs in place on our trading partners. He can also go to Congress and say, pass some new rules. All that is fine. I don't care. I don't care. What I do not want for me, for you, or anyone else is that you have the unaccountability of somebody who has able to take on power that was never intended to be there and to then keep that power forever. So that's it. We're getting close to the end. I appreciate every single one of you. Let me play the music. Nope, there it goes. There, look at us go. We are so good at this. Let's not be hasty. We are so okay at this. As always, I can't thank you enough for your support, for tuning in, for being interested in legal topics. I mean, some people do not like to hear about them, but I'm glad that you have the appetite and the attitude and the aptitude to take a crack at some of these really interesting cases. As we talked about today, broker liability finally before the Supreme Court. Whether you think brokers should be liable or you think brokers shouldn't be liable, we can all agree we like clarity. And I think as you go to Supreme Court, we will have clarity. Good on C.H. Robinson for continuing the fight up to SCOTUS or bust. And of course, the case of VOS selections or learning resources as it relates to the use of IEPA to create tariffs across the entire world with no time duration and no minimum or maximum amount of tariff that can be applied. You should care about this deeply. And I think based on the numbers, you probably do. Now, I'm going to do one last thing because I've done this before. Thank you for my sponsors, DAT, Dial a Truck, 1978, helping people move freight. That's the business of DAT Freight. And of course, Genlogs, Ryan Joyce. Oh, I'm a big fan of Ryan. Technology, hardware, software used to fight fraud, cargo theft, and help answer the age-old question, dude, where's my trailer? We love those trailers. Oh, yes, we do. We do. I will leave you all one last time with our great friend, the Solicitor General, and of course, Justice Gorsuch. Enjoy.
What happens when the president simply vetoes legislation to try to take these powers back?
Well, he has the authority to veto legislation to terminate a national emergency, for example. I mean, he retains the powers in the background because IEPA is still on the books. But if he declares an emergency and Congress doesn't like it and passes a joint resolution, yes, he can absolutely veto that.
Yeah, Congress, as a practical matter, can't get this power back once it's handed it over to the president. It's a one-way ratchet toward the gradual but continual accretion of power in the executive branch and away from the people's elected representatives.
I disagree with that, and the recent historical counterexample of Congress's termination of the COVID emergency demonstrates that the political oversight
with the president's assent.
Meaningful.
With the president's assent, in fact,
once he lost it by a veto-proof majority in the Senate, I think the position moved. And right. I think he realized, and that's the political process working. There was a political
it takes a supermajority, a veto-proof majority to get it back. Yeah. Okay.